Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, When Mediation Makes Sense, Preserving the Business Relationship from the Perspective of a Corporate Lawyer. This event is brought to you by Law.com and sponsored by National Arbitration and Mediation. Before we begin, let's go over some basic housekeeping items about the webcast console. First, this event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without having to open a new browser. Just scroll along the bottom of the screen and click on the social networking widget of your choice. If you have a question for our speaker, please enter it in the Q&A widget on your console. We will get to your question either during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So please feel free to change the look and feel of your console as it suits you. Also, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. Participants who wish to receive credits for other states must check directly with their CLE board. Within an hour after the presentation, all attendees will receive further instruction via email on how to receive your CLE. During this presentation, the CLE code will be announced. New Jersey and New York attorneys should be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. The CLE certificate will be available for download 1 week after the event, on September 19th. CLE credit is available for attorneys in the approved jurisdictions, provided that you viewed this live event for 50 minutes or more. And now for today's topic and the reason you are all here. Litigation often comes with uncertainty and unexpected costs. However, alternative dispute resolution methods, such as mediation, can be a better alternative to resolve business disputes. Here to shed light into the mediation process and how it can be leveraged to resolve disputes and retain business relationships is Michael Emerson, Esquire and former General Counsel at Signature Bank, as well as hearing officer at NAM. Michael is a financial services industry veteran who has practiced law for more than 35 years. So Michael, welcome, and thank you for joining us today. I will go ahead and kick it over to you to jumpstart the discussion.
Thank you very much, Kelly, and welcome everyone, and good afternoon, and thanks for joining in. So I'm going to make this presentation from the perspective of a deal lawyer rather than a mediator or a litigator. And this is due in large part to my legal background and experience, which, as Kelly just mentioned, was primarily as a general counsel or a senior counsel at a number of large financial institutions. Most of my experience earlier in my career was as a transactional lawyer representing clients, including senior management of these institutions, in a wide variety of transactional and other legal matters. As one might expect, despite my best efforts, some of these deals resulted in problems with counterparties. Certain of these problems were addressed through litigation. Others were resolved through mediation. And to be clear, my experience with mediation and litigation has turned me into a big fan of mediation. Of all the mediations and litigation I have seen over the years, I have found that mediation makes the most sense when there's an existing relationship between or among the parties. This can be between employer and employee, customer and vendor, or even competitors. And when I refer to a relationship, I really mean the circumstances where the parties know each other, they've dealt with each other over some period of time, and where their dealings with each other are meaningful. I would contrast this with being a customer of a merchant who purchases a good or a service without really knowing more about or having a background of dealing with each other. I say this because when you get right down to it, a mediation is simply a negotiation. There's clearly a sense of trying to get what you can, but there is also a need to make the compromises and concessions that will permit the mediation to succeed. I have found that there tends to be a greater willingness to do that when there is knowledge of excuse me, or familiarity with the person or people sitting across the table, and the relationship that exists is valued. Those same relationships can be present in litigation, but the outlook or mindset of the parties in litigation tends to be very different. Whether it is the fact of a more formal setting, excuse me, with litigation, I don't know. However, with litigation, it is as if there's a sense of war rather than peace, of winning rather than resolving, or of challenging rather than negotiating. To me, it's the attributes of mediation, which I will review with you shortly, that are the biggest reasons why I believe it will preserve the business relationship. So when you get right down to it, what are the reasons to litigate rather than to mediate? First, is it to create precedent? Well, it can if you get the result you want, but it can also backfire if you don't get the result you were expecting or needed. Second, is it to punish your adversary? Clearly, that can be an objective of litigation, but litigation is lengthy, it's tough, it's uncertain, and it's an expensive process for both parties, the winner and the loser. It can literally take years to get a final result in litigation. And how do the parties deal with each other while this is ongoing? Might there be a better approach or an easier way? I suggest there is more than enough pain and suffering by both parties to a litigation. So third, is it the cost? As we will see, litigation is overwhelmingly the costlier approach to dispute resolution, both for the plaintiff and the defendant. Fourth, how about the time required? It is typically years for litigation compared to days or at most weeks for mediation. And fifth, how about control of the outcome? In fact, there is no control in litigation where a judge or jury will make all determinations versus complete control in mediation where nothing happens without the agreement of the parties. And last, privacy. Well, privacy only exists for mediation. So I came across a recent statistic that actually blew my mind. It's that 95% of pending lawsuits end in a pretrial settlement. I just couldn't believe that. With that being the case, I don't understand why parties don't just start out with mediation and avoid all the expense, delay, posturing, time commitment, and other aggravation associated with litigation. So let's turn to page 3 and just touch on the agenda for today. There you go. So today we're going to talk about these items. I don't need to read them. You're capable of doing that. Just to take us through the program. I'll touch on each of these and we'll just see what happens. Let's go to page 4. So in my view, mediation should actually be a required first step prior to proceeding with litigation. In fact, under New York State Chief Judge Janet DeFiore, certain parts of the New York State court system have recently begun incorporating mandatory mediation into its civil case protocol. In mediation, the parties and the mediator whom they select meet to discuss their dispute and attempt to consensually agree to a resolution. So this session will compare and contrast mediation and litigation at a high level, and will then discuss the benefits of mediation generally, but also in the context of important business relationships. So the following are some relevant questions to ask when faced with a dispute that needs resolution. How did the dispute arise? So what went wrong that couldn't be resolved informally? This happens all the time for a variety of reasons. Some parties are convinced that they should or will win if they litigate, and they don't care about the cost. Others, frankly, have egos that won't permit them to compromise, even if it will resolve the dispute quickly and avoid them losing. Second, who is the dispute with? Is it with a customer, a vendor, a business partner, or someone else? I think you should ask yourself, how important is the relationship to your business or other affairs? Third, what is the nature of the dispute? Is it based on a simple misunderstanding? Or is it a more fundamental disagreement or conflict that will continue to impact the business until it's resolved? Fourth, what needs to be done to resolve it? If it's with a business partner, is it so critical to the business arrangement that it needs to be resolved immediately to allow the business to continue? Or can it be put to the side and resolved at some later time? Answers to these questions, and likely others, will inform the decisions that need to be made about how best to resolve the dispute and move forward. So welcome to the world of mediation. If it is the case that the matter is both important, say to a business relationship, and needs to be resolved quickly, the question then becomes, what is the most effective way to do that? I would suggest that the assumption is often made that formal litigation is the only way to put a matter to rest. If I am correct, I suggest that the parties may not have a sufficient understanding of what mediation can achieve, and that litigation may be all people generally think about that. The simple fact is that mediation can often provide a quicker, less costly, and better result for the business or other relationship, and one without one of the parties needing to feel that they either lost rather than won the dispute. So what is mediation? Mediation is a form of alternate dispute resolution, or ADR, that takes or keeps the dispute out of the courtroom. It does this by placing the dispute in the hands of the parties with the assistance of a mediator or neutral to resolve. The role of the mediator is to listen to and engage with the parties and to use that information to identify ways to encourage the parties to resolve their differences. One of the advantages of mediation is that if it is successful, the parties reach a consensual resolution, which can eliminate the hard feelings associated with losing or even having to go through the litigation. So let's take a closer look at mediation versus litigation. Litigators typically know all too well how extremely expensive and time-consuming it is to formally litigate a matter. The pleadings, discovery, motion practice, and then ultimately going to trial, as well as the time and billing rates of counsel, can result in tremendous cost to the parties to the dispute. It can also result in significant delay, often years, from the filing of the complaint until final judgment is awarded, potentially including an appeal. In contrast, mediation generally affords the parties an opportunity for a much quicker and less expensive resolution of their dispute. A mediator can be selected quickly, often in a matter of days. Although each mediator may have his or her own requirements or preferences for the exchange of documents and other information, in general, this is done quickly and inexpensively, and typically represents but a small fraction of what is required in formal litigation. So let's look at the time involved and other requirements. Mediators may require the parties to prepare and exchange a pre-mediation brief or document, particularly for more complex mediations. These documents will typically set out the facts of the dispute, the applicable law, and they may also set out each party's legal positions. Once scheduled, mediations generally only take a single day for more straightforward matters, or only a few days up to a few weeks for the more complex matters. Unlike litigating a matter subject to the standard operating hours of the courts, it is not unusual for mediations to continue well into the evening, particularly when a resolution may be imminent. Unlike litigation, where one party wins and the other party loses based entirely on a decision by the judge or a jury, mediation can produce a virtually unlimited range of outcomes, with varying amounts of damages and other required actions that the parties themselves determine they require to resolve their dispute. It's important to keep in mind that the resolution of a matter in mediation is entirely consensual. This means that the parties will have approved the outcome before the mediation concludes. In addition, mediations cannot be appealed. So, unlike litigation, there is no risk of a different result upon review of the matter. Decisions in mediations can include money damages, as that is often what one or both of the parties requests. There are also a variety of non-monetary outcomes possible. These include, for example, restrictions on future business activities, employment restrictions, and agreements either to do or refrain from doing certain things. This list is limited solely by the imagination of the mediator and the parties. So what do the parties really want? Are they simply looking for an opportunity to talk and be listened to? I suggest that sometimes, particularly in mediations, what a party wants more than anything is to have the other party listen to what it has to say. Alternatively, are they requesting a specific outcome, or are they open to a range of outcomes? I recently participated in a mediation I found particularly fascinating. Two large companies that together dominate a national market had dealings with each other involving a range of activities. They also had a long history of working together. Several of their dealings were essentially joint ventures, while in other cases their relationship was more arm's length. At the end of the day, it became clear that what drove the parties to mediation was simply their inability to work with each other informally to resolve their differences. And I found that particularly interesting given their extensive, constructive, and long-standing relationship, particularly related to their other business dealings. Nevertheless, they appeared hopelessly deadlocked and fully prepared to proceed with litigation if the mediation was not successful. It also seemed apparent that a failure to resolve their differences could completely end their relationship and their businesses. Now, I'm not a psychiatrist, so I can't say with any confidence exactly what drove them to this situation. What was clear, however, was that the outcomes they were seeking were really non-monetary. More than anything else, one party, who I'll call the first, seemed to be looking for an acknowledgement of the contribution that it felt it was making to the joint venture in particular and the other relationship, and the hardship it was encountering in performing under their agreements. I also felt the first party also felt the second party was not holding up its end of the bargain. So the first party was also looking for an agreement to make the changes it felt were necessary to be able to continue in the relationship. And these were huge companies with billions of dollars at stake who had been in business for decades, and to think that they got to the point where their preferred approach to resolving their issues was a mediation was just incredible. And suffice it to say, I don't think they could have accomplished the same thing in formal litigation. So at the end of the day, neither of the parties in the mediation may get exactly what they believe they deserve. But mediation is consensual, and there may be a variety of non-monetary outcomes that provide greater value to the parties and which may be more difficult to achieve in formal litigation. Many of you know better than me, either through your professional experience or your general expertise, the extent to which information in some way related to litigation can find its way into the public domain. To me, this is simply frightening. Whether it's trade secrets, confidential information, proprietary information, customer information, future plans, proposals, and the like are all equally at risk. And while getting documents sealed in court is possible, I understand that this can be quite uncertain. So that begs the question, why not mediate? It's always private. By the way, in case you had no idea, although I think you should be sensing this, I'm a huge fan of mediation, which is actually saying something since my wife is a New York State Supreme Court Justice. I don't really say that around her. My background was steeped in litigation. I worked for big banks and investment banks in New York City. When problems arose, we routinely sued and got sued. All the time. Over everything and over nothing. The suits and the outside counsel were both ridiculously expensive and took way too much time to resolve. One of the reasons I joined NAM is because I fully expect mediation to continue to rapidly develop and become the approach of choice, even the gold standard, to resolve matters between parties. This is particularly so as court calendars continue to get bloated and the time required to resolve disputes through the court system continues to increase. I'm sure there are litigators in the audience who will disagree with me that not much can be done to obtain or prevent a particular outcome in litigation. While there are tools and tactics available to help get what you want, at the end of the day, the decision belongs to either a judge or a jury, not one or both of the parties. Now, I'm just offering my perspective as an in-house counsel. That being said, I firmly believe that mediation, because it is consensual, offers much more control than does litigation over both the process and the outcome. And I think it's important to recognize that a bad case is still a bad case, even in mediation. However, the parties in a mediation retain the ability to manage the case to a less harsh or bad outcome, or to no outcome at all. So maintaining or preserving the business relationship is, to me, one of, if not the biggest potential advantage of mediation over litigation, or even arbitration. And it is really the nature of mediation, which is consensual and done at the direction of the parties, which has the ability to achieve this result. So in mediation, the parties retain control over the process and the outcome. This is perfect for your classic type A personality who wants to remain in control. Think senior management. That said, mediation still requires a good faith approach and negotiation. You can't really manipulate the process, impose your will, or be assured of getting the exact outcome you desire. In fact, it is often said that the best outcome in mediation is where both parties feel that they lost, or that at least they didn't get everything they wanted. So I want to review some things to think about when deciding if mediation, rather than litigation, might be the best approach for your matter. First, is there a concern about the dispute or any matters related to the dispute becoming public? Is anything confidential? Is anything proprietary? Is a trade secret involved? Does it present reputational risk? And will it involve the disclosure of any other information you believe needs to remain private? Second, are the parties looking for a quick resolution? As we all know, litigation can take many years to resolve, particularly with appeals. Mediation, on the other hand, can be completed in a matter of weeks or months. Third, what is the budget for getting the matter resolved? Litigation can be painfully expensive and slow. Mediation provides an opportunity for quick resolution. Fourth, what is the relationship between the parties? To me, this is a key consideration. If the parties have a strong and ongoing business relationship, and they want or need it to continue, mediation will likely be clearly preferable. Let's face it, following the completion of a litigation, the parties are very likely to feel quite differently about each other, their relationship, and their willingness to do business with each other going forward. Fifth, where the time required to litigate or the cost of litigation exceeds the value of the claim. If resolving the claim is important, say for non-economic reasons, or it's really a non-economic claim, such as personal pride or satisfaction, a matter of principle, or other similar reasons, mediation may well provide a better result. Sixth, where liability has already been established and the only open issue is the amount of the damages. This is actually a perfect situation for mediation. It should be much more straightforward and cost-effective for a mediator to work with the parties to reach an agreement than having to go through formal litigation to do this. All right, choosing a mediator. How is this done? Unlike litigation, where a judge for a case is either assigned randomly or through some prescribed protocol, in mediation, the parties choose who will mediate their dispute. I think this is a particularly valuable attribute of mediation, but there are a number of considerations. What are the parties looking for in a mediator? Is it someone who will suggest options or alternatives to help move the parties toward an agreement? Or is it someone who will simply leave it to the parties to determine how to do this? This will largely depend on the parties, the nature of the dispute, and what they are looking for the mediator to do. Are the parties looking for someone who's a subject matter expert for their matter? Many parties strongly prefer a mediator who is familiar with, and perhaps even has had expertise with, the issues involved in the mediation. Are the parties looking for someone who has a track record of experience and or success in their type of matter? Would someone with a specific background or expertise in a particular area of law be beneficial to their case? And what is the reputation of the mediator the parties are looking for? Is it someone who is known to be more of a take-charge person, who is aggressive in promoting a resolution? Or is it someone who takes a more passive approach, who will direct the discussion but leave it to the parties to craft their own solution? Consider the opinion of others who have used the mediator or your own previous experience with that mediator. And if applicable, consider the goals and procedures of any organization with which the mediator is associated. So in my case, that would be NAM. And there are two common models of mediator. The first is called facilitative, where the mediator doesn't have or use any particular subject matter expertise. The mediator is more skilled in negotiation and conflict resolution techniques. The second model is the evaluative. This mediator will evaluate the strengths and weaknesses of each side's positions and help shape the discussions and will actually try to influence the decision. You should decide which approach is better for your matter. You should also consider interviewing one or more mediator candidates before making your selection. So Kelly, let me stop now and just let you present the CLE number.
Great. Yes, thanks, Michael. So the CLE code for our event today is Law 19. That's LAW 19. Again, the code is Law 19. And with that, I'll pass it back over to you, Michael.
Okay, thank you. So now let's talk about how to prepare for a productive mediation experience. So let me highlight some suggested steps to take and other things to do to prepare for your mediation and make it more productive. You should be prepared to submit a pre-mediation statement or any other documents requested by the mediator. This will allow the mediator to review and make certain he or she understands specifically what the matter concerns and to prepare for the mediation in advance. The pre-mediation statement or other document may be confidential, or it, or parts of it, may be shared with the other side. Getting everything on the table as early as possible, both the good and the bad, is typically beneficial for resolution of the matter. Holding back or trying not to disclose your side's weaker points or problem issues is generally discouraged. They will likely ultimately come out. Remember that each party to the mediation likely knows as much about these matters as the other party. And it is generally best to avoid being viewed as trying to hide anything. The pre-mediation statement often makes sense with complex cases where the statement will include detailed facts with documentation support and will address important issues of law. This can help set the stage for the mediation and allow everyone to get focused on resolving the issues early on in the process, rather than wasting the time in the actual mediation to do that. Make sure you understand exactly what the mediator is requesting, and make sure that is what you provide. There is a risk that by misusing this opportunity and either providing something the mediator has not requested or omitting something the mediator has specifically requested, a party can further alienate the other party and potentially create mistrust or suspicion on the part of the mediator that can be difficult to overcome. I also want to emphasize that an essential element to resolving the dispute in mediation is trust. If trust is lacking, then don't expect much good to happen. Each party needs to believe and to feel that everything has been disclosed. both the strong points and the weak ones. Each of the parties will have a sense of how much to trust the other party, based on the facts and circumstances that brought them to the mediation. The mediator will likely have determined whether or how much to trust each of the parties based on their interactions and how they dealt with each other to that point in the mediation. Remember, the case should be presented in the best light possible, but keep it factual. Remember, you're not trying to convince a judge or a jury who will be deciding the matter and who may be hearing about what happened or didn't happen for the first time. If anyone, you are trying to persuade the other party. At the end of the day, the parties will need to agree as to how the matter gets resolved. Each party will surely have the same information as well as its own view of the matter. At the end of the day, the mediation will only be successful if both parties agree on the proposed outcome. Don't make things worse by misstating things. And don't think about winning per se. Instead, think about what success will look like. What outcomes can each party view as having successfully resolved the dispute so that life can return to normal, or at least to what it was before the dispute arose. And particularly where a dispute is not central to a party's business relationship, and perhaps it is simply an annoying aspect of the relationship, the mere fact that the issues being mediated will be resolved may end up being more significant and more valuable to the overall relationship than the outcome of the particular issue resolved. Be flexible and keep an open mind. Encourage your client to approach the mediation without any specific outcome in mind. The mediator may suggest unexpected or unusual ways in which resolution of the matter could be achieved. Be professional, but don't pull your punches. Don't be afraid to tell it the way it is. It's important to be civil and respectful, but you don't necessarily just have to be nice. It is important to be able to tell your side of the story, and in your own words, and in the way you feel best describes your position. It will be difficult for the mediation to be effective if particular facts and other relevant issues were never discussed. Finally, and importantly, be mindful of existing relationships. If you find yourself mediating with an existing customer or anyone else with whom you have an ongoing business relationship, understand that the mediation is typically less filtered than litigation. Parties to a mediation will typically have more direct access to each other, and things that are said and done are likely to have a greater and more direct impact than would be the case when they are filtered through the lawyers in litigation. This often contributes to the mediation being quicker at resolving the dispute, as things are commonly said and done in very raw and unfiltered form. So just a couple of final thoughts. It's important to recognize that mediation need not be regarded solely as a complete substitute for litigation. It obviously can, but rather as a companion tool that can be used surgically and precisely as needed. So, for example, consider turning to an experienced mediator for issue resolution to smooth out thorny discovery issues, particularly those where knowledge of transactional documents, books and records, financial statements, or regulatory requirements can be useful. A mediator can even be used to act as draftsperson of the final agreement that resolves the matter. Finally, in addition to efficiency, cost savings, and finality, mediation, unlike litigation, allows the parties flexibility and creativity to find business-like and client-driven solutions. Mediation can include all issues between and among the parties that may not fit within the confines of formal litigation. Maintaining or preserving the business relationship is one of the biggest potential advantages of mediation over litigation. And it is the nature of mediation which has the ability to achieve this result. So that concludes my formal presentation, and thank you very much for listening.
Excellent. Well, thank you, Michael. A lot of great, valuable information there. We do have some time left in the hour, and we want to encourage everyone in the audience to ask Michael any questions you may have by entering them in the Q&A widget on your console. We have had some great engagement already from the audience, so let's go ahead and read some of those questions out at this time. The first question that we have here is, how does somebody arrange for a mediation?
Well, there are a number of ways to do that. There are associations or organizations like NAM, which sponsors mediations on a large scale. And the mediations can be arranged by contacting NAM and speaking to people here who will explain the process that's involved in terms of location, how to select your mediator, who to select or who is available to be selected, how to coordinate with the other side to the dispute, et cetera. So that's a very easy way of doing it. There are also a number of independent mediators who I'm sure have their own requirements for getting involved.
All right, great. Another great question we have here is, are all cases appropriate for mediation? Are there some that just may not be?
There probably are. It's my sense that any type of a case that can be resolved by the two parties directly is appropriate for mediation. Now, there may be cases that require some third party or someone else to get involved to provide assistance or direction or to implement the results, but in general, if it's a dispute between two parties that they can resolve themselves, then it's appropriate for mediation.
Okay, great. Another person in our audience would like to know, are all mediators former judges or attorneys?
That tends to be the case, although there's no requirement that that be the case. So there are non-lawyer, non-judge mediators who will hear a variety of different disputes. I say that's far less common. It's really more typical that you're going to end up with a judge or a practicing lawyer.
Right, okay. Would you recommend including mandatory mediation provisions in business-to-business contracts?
I absolutely would, with no reservation, principally because I think it's an excellent first step and probably less costly and more efficient, and for all the other reasons that we reviewed today. Why get bogged down in litigation unless you absolutely have to? And you can certainly put these provisions in your agreement, and if the mediation doesn't work out, you can end up in litigation. So you're not really costing yourself anything, and you may end up saving yourself quite a lot.
Sure, that's great guidance. The next question we have is, are mediations limited to big cities such as New York City?
They're really not. They may be more common and more frequent in the bigger cities like New York City, Boston, Chicago, cities in California. But NAM in particular has an extensive network of mediators who I think can be available within some short distance. I don't remember whether it's 10 miles or 20 miles of the parties involved in the dispute. So it's very easy to arrange this wherever you are.
Excellent. And someone else would like to know, is it best to bring an attorney familiar with mediation? I would say likely yes, but what is your take on that?
I think whoever can provide the guidance you're looking for. So I think as a general rule, having a lawyer or a judge there to represent you is beneficial, but there may be non-lawyers or others who are very familiar with mediation, or oftentimes you can do it yourself. You probably don't want to do it yourself if the other party is represented by counsel, but it is possible.
Okay, and we have another question, good question here. In your agreement, can you stipulate mediation first, and if unsuccessful, then arbitration?
Sure. Yeah, absolutely. And you could do it the other way around as well. I mean, this is a matter of negotiation and agreement between the parties, and there's really no right or wrong answer. It's whatever you're comfortable with and what you can get your counterparty to agree to.
Okay, well, with that, we are getting close to the top of the hour. So at this time, I'd like to thank you again, Michael, for all of your valuable insights today, as well as Law.com for their support. Thank you, of course, to everyone in the audience for joining us. We hope you found this discussion useful. And just as a reminder, all participants will receive an email shortly after this event with detailed instructions on how to receive your CLE when it becomes available on September 19th. You will then receive an email 1 week from today also with instructions on downloading your state-specific CLE certificate. And remember, this webcast will be archived so that you can refer to it later on as desired. So with that said, thank you, everyone, and have a great afternoon.